In a television crime show from the later quarter of the last century, Robert Blake's character, Beretta, used to say, "If you can't do the time, don't do the crime." Of course, he said it with a New York accent. Elizabeth Holmes should probably have listened to him. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. So today we are going to talk about the conviction of Elizabeth Holmes and the appeal that she made to the Ninth Circuit. But before we get there, we need to do a little bit of background. Elizabeth Holmes was the founder and former CEO of Theranos. That was a company that was dedicated to changing the way the healthcare system worked. She was convicted of fraud in relation to charges about misleading investors and patients about the capabilities and reliability of her company's blood testing technology. So here's what led to her conviction. Founded in 2003 by Holmes, Theranos claimed to revolutionize blood testing by using a proprietary technology that could run a wide range of blood tests with just a few drops of blood. This innovation was touted as faster, cheaper, and more efficient than traditional methods. Well, first of all, she misrepresented the technology. Holmes and her company made false claims about the accuracy and reliability of their blood testing technology. Despite internal reports and issues, they asserted that their devices could perform comprehensive tests accurately and reliably. That just wasn't true. Second, they used deceptive practices. Theranos allegedly used commercially available machines from other companies to run tests while claiming that their own devices were being used. This misrepresentation was crucial in deceiving stakeholders about the technology's capabilities. Investor fraud. Holmes provided misleading company information to investors, and you can't do that. The Securities and Exchange Commission requires brutal honesty in these disclosures that are made to investors. And all of the things that she was misrepresenting to other people, she was misrepresenting to her investors. All those things included overstating revenues, omitting critical information about the technology's limitations and its failures. The company also provided inaccurate test results to patients, potentially leading to incorrect medical treatments and diagnoses. Holmes was charged with several counts of wire fraud and conspiracy to commit wire fraud. These charges related to the use of electronic communications and the Postal Service to execute a scheme to defraud investors and patients. So that's mail and wire fraud. In January of 2022, Holmes was found guilty on 4 counts related to defrauding investors. She faced a significant prison sentence and fines as a result of those convictions. In fact, she was sentenced to 11 and a half years in federal penitentiary. She was sent to a prison camp in Bryan, Texas. The case of Elizabeth Holmes and Theranos is one of the most high-profile cases of the corporate fraud in recent years. It highlights the issues of corporate governance, transparency, the consequences of misleading investors and the public. Holmes' conviction serves as a cautionary tale for tech startups and the broader business community about the perils of overpromising and underdelivering, which is exactly what she did. The disgraced former CEO spoke to people in her first interview since being found guilty of fraud. At this point, she says it's been torture and hell. She maintains her innocence and says that being separated from her 2 young kids shatters her world. So, do they have her out there on the rock pile making little ones out of big ones? Or making license plates? Or maybe doing some other hard manual labor with a rake and a hoe and picking weeds up and that kind of stuff? No. The hell that she's going through, I feel so bad for her. Her daily routine includes a workout, largely vegan meals, teaching French to other inmates, and working on her campaign to reform the criminal justice system, ostensibly so that people who commit fraud can get away with it, I guess. I don't know. At any rate, that is what Elizabeth Holmes is doing right now. Her campaign to reform the justice system has not been going particularly well for her. because her appeal was decided on the 25th of February, and, well, let's just say it didn't work out for her. Like most cases in federal court, the appeal starts with a summary, and it says the panel affirmed Elizabeth Holmes and Ranesh Sunny Balwani's convictions on numerous fraud charges, their sentences, and the district court's $452 million restitution order in a case in which defendants defrauded investors about their achievements of their company, Theranos Blood Testing Technology. Defendants argued the district court erred by allowing former Theranos employees who testified as lay witnesses to offer expert testimony. The panel explained that if a witness offers an opinion that is based on specialized knowledge, experience, training, or education contemplated by Rule 702, which is the rule that governs expert witnesses, a party cannot evade the rule by labeling the witness percipient, and there is no on-the-job exception to Rule 702. But the fact that a witness's testimony pertains to scientific matters or conveys a witness's opinions drawn from the witness's own experiences with such matters does not automatically render it expert testimony within the Rule 702. Considering each of the challenged witnesses with these principles in mind, the panel held that some aspects of their testimony veered into expert territory, but any error was harmless. Holmes argued that a report prepared for the by the Center for Medicare and Medicaid Services was irrelevant under Rule 401 and should have been excluded because there was significant risk that the report would mislead the jury. The panel held the district court did not abuse its discretion in finding the report was relevant to Holmes' knowledge, intent, or state of mind, and in finding that it wasn't substantially prejudicial. Holmes argued that the district court abused its discretion by allowing testimony that Theranos voided all patient sample tests run on a device used in Theranos' clinical lab. Federal Rule of Evidence 407, the remedial measures rule, says that you can't do that if its purpose is to prove culpable conduct. And of course, that's what it was for. The purpose of Rule 407, though, is to avoid punishing the defendant for efforts to remedy safety problems. It's not implicated in cases involving subsequent measures in which the defendant did not voluntarily participate. The panel held the district court didn't err, and they also argued Sixth Amendment and Federal Rule 804 about portions of deposition testimony by Balwani to the Securities and Exchange Commission. Balwani argued that the indictment was constructively amended in violation of his Fifth Amendment rights when the government presented evidence concerning the accuracy and reliability of Theranos' tests run on conventional technology, even though the indictment only charged him with misrepresentations concerning the accuracy and reliability of tests run on proprietary technology. So, like I said, things have not been going really well for the Lizzie Borden of healthcare. And as a result, she lost her appeal. Now, I could go into the weeds on that much further, but I think I'm just going to hit a couple of high points because we've talked on the channel about scientific evidence and the Daubert rule and why it's so important to validate the science that goes in front of a jury because most jurors don't have a scientific background. And sadly, most judges don't have a scientific background either, but they're the ones who are evaluating the admissibility of this evidence. So let's talk a little bit about the Ninth Circuit's ruling here. So both Holmes and Balwani argued that the district court erred in admitting this evidence from Theranos employees. It says they review this under the abuse of discretion standard. Under Rule 701, a lay witness may provide opinions rationally based on the witness's perception that are not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. Opinion testimony requiring special knowledge, skill, experience, training, or education is subject to the requirements of Federal Rule 702, Daubert versus Merrill Dow Pharmaceuticals, and the disclosure requirements of Federal Rule of Criminal Procedure 16. Whether evidence is more properly offered by an expert or a lay witness depends upon the basis of the opinion, not its subject matter. If the basis of a witness's opinion is technical or specialized knowledge, then that opinion falls within Rule 702. But if the basis of the opinion is just familiarity with the subjects, then it's proper lay opinion. Drawing that line is a particularly difficult task in a case like this. By the very nature of the facts and the alleged fraud, the testimony of percipient witnesses, in other words, those who perceived things, will inevitably involve observations made in a scientific setting and relate to scientific or technical concepts. But the fact that a witness's testimony pertains to scientific matters or conveys opinions drawn from the witness's own experiences with such matters doesn't automatically render it expert opinion. And then they go through some of the things that explain that, and they say, thus, as we explained in Figueroa Lopez, if a witness offers an opinion that is based on specialized knowledge, a party cannot evade the rule, Rule 702 or 701, by labeling them percipient. And the converse is also true. An opinion is not automatically deemed expert within the meaning of 702 merely because it's offered by a lay witness drawing on their own unique experiences or personal knowledge. With those principles in mind, we consider each of the witnesses. So the first guy is this Dr. Kingshuk Das, who testified against them, and he testified that in responding to the CMS report, he was involved in Theranos' performance of patient impact assessments. In other words, CMS asked whether Theranos' poor performance of these tests impacted patients, and he set about to determine that. So he testified about that, and he said that he conveyed the results of his efforts to Holmes. Holmes attributed the poor results to laboratory control failures rather than an issue with the device itself, an explanation that Das found unsatisfying. So, those of you who may not ever have worked in a clinical laboratory may not understand that about the laboratory controls. When I worked as a respiratory therapist in Florida, in order to maintain certification, our blood gas laboratory had to run a series of blind controls that were sent to us by the College of American Pathologists. So we would get these little tiny ampules and we would break them open, draw out the fluid, put them in the blood gas machine, and report out the results on a form that was sent back to the College of American Pathologists. And we either got it right or got it wrong. And of course, if we got it wrong, well, then they would decertify our machine until such time as we could get it right. It never happened while I was there that our machine ever got decertified. But what you can't do if you are putting out equipment is say, well, it must be the controls, since those controls are fairly rigorously put together and analyzed, and they are tested repeatedly to make sure that the results that you are going to get are going to fall within a particular range. And so the idea that these would have been outside the range because they were bad controls was just nonsense, to put it politely. So the government says, hey, look, this Das guy was just a percipient witness because he just described the job he was hired to do. It's not expert testimony, but rather it's an admission by Theranos and by extension Holmes that there were serious reliability issues with the Edison device. That was the name of the product that they had developed that's supposed to run these tiny blood samples. And the Ninth Circuit says, not so fast there, guys. The government's argument is misplaced. As we explained, there's no on-the-job exception, and there's little doubt that the PIA and DAS's opinions concerning the suitability of the Theranos device for clinical use were based on specialized knowledge. So they should have run him through the Daubert rule, and they say, more importantly, the district court recognized before trial that the Six Sigma data, which was a part of this, the second retrospective analysis of the Edison that Das conducted, would have approached expert witness territory. So they go on to say, look, he should have been subject to the Daubert rule, but it said, look, any error in admitting these opinions was harmless because other people testified to the same thing. And there was an issue of waiver. Moreover, after the district court permitted the government to call Das, Holmes never requested a Daubert hearing to test the reliability of his testimony, nor did she object when Das offered the opinions she now challenges. Only when the court admitted the PIA, the patient impact assessment itself, did Holmes raise a 702 objection. There was no reversible error by the district court. And they reached pretty much the same conclusion about Dr. Rosendorf and Dr. Pandori, because they too are simply harmless error, as the Ninth Circuit looks at it. And in Balwani's case, Erica Chung, the former Theranos laboratory associate, also offered expert testimony in violation of Rule 702. And we know that because the appeals court says, we therefore conclude the district court did not abuse its discretion in admitting Chung's testimony about quality control problems that led her to question the accuracy and reliability of Theranos' device as lay opinion. And that's pretty much the way the rest of the opinion goes. They don't find anything that would merit a reversal of the conviction or a change in the sentences or anything like that. It was a long shot at best for Holmes, and she missed the mark. I'm a little bothered by the fact that you admit that the testimony was scientific and you didn't do a Daubert analysis, but you let him off the hook because other people testified to the same thing. That seems to be rather odd, since for the most part, courts really don't like repetitive testimony, what the courts call cumulative evidence. In other words, you just keep piling on logs on for the same thing. The courts don't like to see that. Holmes' case is a cautionary tale. It truly is. And the idea that she had, which was that she could sucker all of these investors and somehow run away with the money, it never made sense. And I wonder at what point in time that this giant Ponzi scheme she was running, I wonder when it occurred to her that, hey, I'm going to go to jail. And I wonder also if giving up 11 and a half years of your life is worth it to get, 15 minutes of fame and a little bit of money, or a lot of money for a very short time, because she sure didn't get to keep very much of it. At any rate, that's what I have for you today. Thanks so much for watching. Come on back, join me down here tomorrow. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.